What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we are going to go through in its entirety Karen Reed's amended complaint. Let's get to it. All right, so obviously off the top, I want to apologize for the last video on this topic because I had read the first complaint obviously a long time ago. I read the amended complaint when it first came out while we were covering other things. And also I read a million articles breaking it down, talking about what's different, what's additional, explosive new things. And I made a bunch of notes, and instead of reading the actual complaint, I read from some notes, some things I copy and pasted, obviously from places that I did not go back and check the original complaint to get the exact language, whether things had added language, subtracted language, things that weren't there, or were quotes that weren't quotes. It's all on me. So I absolutely apologize for that. And people ask sometimes, why do you read the entire document? Why do you read 50 pages? It's so boring. It's so long. Isn't it easier just to summarize? And sometimes when you summarize, you can get things wrong. Sometimes when you mix in your opinion of what something looks like, or you're taking something from a quote or from a trial or from a hearing or from something else that wasn't in the document and add to it, it can be wrong without the proper context. So getting it right is the most important thing, obviously. And by the way, I don't really care about the jerks and the people that have the gotcha culture and act like, oh, wow, we got him now. Like, I'm going to make mistakes. It's going to happen. I've done hundreds of videos, probably thousands of hours of content online. I have done something like this one other time where I made a mistake that I can remember. I'm sure I've made other mistakes. Okay, I'm sure I have. But where I went on and, again, had to kind of clarify what I said. I was wrong about something. It was like medical in one of the videos that we talked about. And you guys were the best. And that's why I'm doing this, because the people that actually are here to care, to learn, that trust this channel, that interact with this channel, that are part of this community, I want to get it right. And I think that that's really important. I think that's the most important thing. I don't care about narratives or pushing one angle or another. Some people, I mean, most of these people that are getting up in arms lie about most of the stuff they talk about on social media or whatever, as it is, because they want to push certain things and do certain things. We will never do that here. Right? We will take an unpopular opinion if that's what I believe to be right, or that's the argument I'm discussing, or what a lawyer is doing in a situation. But I absolutely need the grace I so often ask for you guys to give other people, and that I try myself to give other people. It's not easy, but I also find it hardest to give myself grace. So John has been talking me off the ledge since this all happened. And I know a lot of people are going to be like, oh, it's not that big of a deal. It just... If you know me and you know when the camera freezes or pauses or whatever and how frustrating that is to me, this is times a billion to that. So if I could go back and make it never happen, I would, but I can't. So the next best thing is, because I love this community and I love doing this for the most part, it can be miserable at times, obviously, but I wanted to just go back and do it the right way. So we're going to bite the bullet, and my penance for this, for trying to bite off more than I could chew and not doing it the right way and not doing it the way that we've always done it, we are going to do it that way. And we are going to read the entire 54-page complaint. We are not going to use AI voice. We are going to use my voice, at least for the most part. Eventually, John might jump on and help me read some of it, which would be much appreciated for my voice, but it was worth it to me to come on and do this so we can see exactly what the amended complaint said. And anything I categorized, summarized, quoted before, I'm just going to ask you, look at this video. This is the correct video. If you want to pull a clip about what the amended complaint says, I'm asking you to pull it from this video. If you pulled it from the last video and people want to run with it, that's fine. I can't do anything about that at this point. I've done everything I can to say there were some problems. I apologize for the lazy way that I did the last video. That is not the way I want to do videos. We talk about it all the time too, like, hey, will you jump in and cover this trial? This is why I don't like skimming things or trying to catch up on 7 days of trial in 2 days. And I want to talk about what the people want to talk about, right? So, this Hawaii trial that's going on, I want to jump in on it, but I know I was either going to have to skim or read summaries of it or whatever it may be. And sometimes that's how you can get things wrong. And so it's a lesson in humility. It's a lesson in patience. It's a lesson in being able to do what you can do. And it is humbling and something that I need a reminder of, right? Because although, everybody knows nobody's perfect, sometimes I do feel like I can be above making mistakes, which is just wrong. And I'm going to make mistakes. And I have to be able to grow from them, fix them, admit them when I see them. And I'm not always going to agree that I made a mistake just because you did. So I know there are people that are going to get carried away with this, but I'm doing my best, and I want everybody to always know that I'm doing my best here. So without further ado, let's jump in and get the correct and proper and straight from the horse's mouth reading of Karen Reed's amended complaint versus Proctor, Buchanan, Tully, the town of Canton, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. And just in case you missed the other video, we talked about Proctor's cell phones. We did that the right way. We actually read the motions on it. So I'm probably going to clip that at the end of this video. It's going to be overtime. Like the video if you want to. If you don't, I understand why you don't. And let me know in the comments if you're going to stick around and watch the Proctor video, which will be not the second half of this video, but probably clipped on the end so you can get the context of why Karen Reed's team is trying to add on to how they can use Proctor's cell phone, because they want to add MSP to a complaint or file a different complaint again against the Massachusetts State Police, but they are not added to this specific lawsuit, but the town of Canton is in the amended complaint. All right. And thanks to Dee Dee for posting the unedited amended complaint that we are going to be reading from here today. For 3.5 years, plaintiff Karen Reed was wrongfully accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct from the MSP and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29, 2022. Also, just for clarification purposes, I am not going to do a fine-tooth comb comparison between this complaint and the original complaint. I clearly do not have the original complaint memorized, but we did a video breaking it down and talking about it as well if you want to go back and check that out. Karen Reed did not kill her then-boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in the defendant Brian and Nicole Albert's home at 34 Fairview Road in Canton in an altercation during a late-night house party with other defendants, collectively the House defendants, after a night of heavy drinking. The House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about how's long to die in the cold, moved Mr. O'Keefe's body outside, and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained in the Alberts' lawn until Karen Reed found him later in the morning. And one of the important things when we're remembering this, a complaint, everything is taken as true when they file motions to dismiss and things like that. The judge says, can they prove these causes of action with the facts they put into a complaint if we take those facts as true? So that's a really important context to read this. That's number one. Number two, Karen Reed is going with a very similar theory to what she had in trial number 1 for her criminal case, where it was a hung jury. So she did not, quote unquote, win with the not guilty verdict. And frankly, if you look at what the jury said, she won on the top charge of the murder charge. But the second charge, there was actually more guilty votes than not guilty votes. So she was not able to even clear the very low bar of highlighting, creating, showing, explaining reasonable doubt. That's like the lowest bar we have in the legal system. This one is a much higher bar, 50.1%. The greater weight of the evidence, she is going to have to prove what she is claiming here. And she's claiming very specific facts about what happened to John O'Keefe, and it was not that he was hit by a car. Now, disproving that he was hit by a car is one thing. Proving what actually happened to him is a very different thing. So those are some of the facts we're really going to pay attention to in this amended complaint. From the beginning, investigators from MSP allowed the House defendants to direct the investigation away from themselves and toward Ms. Reed. So MSP allowing something versus MSP being in on a conspiracy may be two different things depending on who you ask in MSP, but there can be multiple different causes of action. And we know that some of the things, or at least we've heard, some of the things coming will be negligent hiring, retention, and training as far as MSP goes. The House defendants were well-connected and close social group with strong ties to the law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. the lead investigator for MSP, Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent of the Bureau of Alcohol, Tobacco, and Firearms and Explosives. Adhering to the unwritten rule of, quote unquote, protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash on the back of his head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. So will they be able to prove that? And I think the answer is they're definitely going to be able to present evidence of that, because we heard some evidence of that come out during the criminal trial through expert testimony. But we also heard the Commonwealth provide evidence that it was not consistent necessarily with a rigid surface. I think they said it was a star. Am I remembering that correctly? I really need to not even test my memory today with everything that's going on. But they are going to be able to present expert evidence of that, but there will be counter evidence. And will their evidence, meaning Reed's, be compelling enough to get over that more likely than not standard? Because this is kind of like which story makes more sense. That's kind of the civil bar, is they can both make sense. They can both maybe be right, but if one's a little more right than the other, to the tune of 50.1%, you can win a civil case. He also had dog bite wounds and scratches on his right arm and forearm. Where do we think they're going to get that testimony? Right? From one of the more interesting experts that we've seen in any criminal trial. Will the House defendants, law enforcement defendants, these defendants in this case, will they use the same experts the Commonwealth had? I doubt it. They'll use some of them for sure. I think they're going to get their own dog bite experts. That's my guess. But maybe it would definitely be the easier and cheaper road to just use all the Commonwealth experts, because they already have their reports. They already know the case. You already know what they're going to say. If you find it compelling and you think that they're good experts, that might be the cheapest and easiest way to go. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact of a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. So this is really good to disprove something. And there's two ways you can prove that your story makes more sense: to prove your story and to disprove the other side's story. So I still think that's going to be a big part of this case, is for Karen Reed to disprove what the defendants in this case are going to say. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. So now we're seeing some intent, not just allowing something, but doing something intentionally by Proctor. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he's Brian Albert, a Boston cop. And that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear, saying Karen Reed had zero chance of skating, she's effed. The pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Albert's lawn, and Proctor had not even walked into the house, let alone investigated inside the house. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts. One of the big things here, this is a really good argument to say why the Commonwealth cannot prove a case beyond a reasonable doubt. But when I talked a lot about, and people are like, what do you think happened? What do you think happened? My answer has always been, I think the investigation was so bad, I think it's really, really difficult to ever prove what happened inside that house. Well, now Karen Reed's team has taken on that burden in a civil case, and they're going to have to prove it. And this horrible investigation and the fact that they didn't do X, Y, and Z, they didn't interview people appropriately, they didn't record things appropriately, they didn't search the house, they didn't process the house, they didn't secure the scene. So they're going to make allegations. Are they going to be able to actually prove it? Because that's the other thing is, these defendants may benefit from the horrible investigation. And that's what makes sometimes proving things like this, even in a civil case, difficult. The Alberts' German Shepherd was in the house on January 29th, a dog that had a history of attacking other dogs and people. Neither Proctor nor any of the MSP troopers conducted a physical examination of the house defendants for evidence involved in an altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the house defendants' phones, except that which belonged to Jennifer McCabe, who turned her phone over only after making settings changes to the phone February 2nd, 2022. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. So the manipulation and destruction of evidence. In short, by focusing the investigation solely on Ms. Reed, as implicitly directed by the House defendants, through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. So one of the issues here, implicitly directed by the House defendants, I think is going to be more difficult to prove than it may seem. And then through misrepresentations. So if the House defendants lied, does that absolve some law enforcement of some of their activity? If they think they have the key witnesses that were at the scene and they believe them, is that good enough to take some of the heat off of the officers? I think we're going to hear, I don't know how in lockstep all these defendants are going to be, but we might hear something like that. We don't know if what a witness says is true, but when we started gathering the evidence, we felt like the evidence pointed to what they were saying. We'll see. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device and use his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed the information along to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Miss Reed. Okay? And it's important to get that chain of events of who it actually went to. Because I think I said something about Colin Albert there. I don't think that is correct. I was thinking when they talked about the marks on the hands, that's probably where I had Colin Albert in my notes. And then when it got transcribed into the notes, that's where I think I made one of the mistakes. So I apologize for that. And that is the chain of events that was explained in these facts. And I wanted to make sure that gets into this video. Proctor then went so far as to and there may be other issues and other mistakes. And again, I may not highlight other ones. I'm going to read specifically from this document. These are where you should take the allegations and facts from. Proctor then went so far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Miss Reed's vehicle to support the false narrative that Ms. Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. So impugning knowledge on somebody is also something that can be difficult. He's saying he knew this was inconsistent with a motor vehicle strike and consistent with a physical altercation. How obvious was it at the time? Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation, specifically Proctor's private communication to his high school buddies, sister, MSP colleagues that he believed would never be discovered, exposed the corruption at the core of MSP's entire investigation, specifically only hours into the investigation. In a text with 8 of his high school buddies, Proctor said Miss Reed was a whack job C, retarded, nutbag, and a babe with no ass. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text message to his MSP supervisors, that's important, and colleagues, Proctor bragged that while conducting the search of Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully she ends her own life. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct and in some instances expressly encouraged this flagrant abuse of power. For example, no one occasion, Proctor's immediate supervisor, Yuri Buchanan, responded with a thumbs up emoji to a text calling Miss Reed the R word. Proctor's supervisors, and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Ms. Reed, demonstrating a clear prejudice against her from the onset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured 2 separate arrest warrants for Ms. Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for M twice. As alleged below, the unlawful acts not only underlie plaintiff's meritless wrongful death claim against Ms. Reed, but they also form the foundation of Ms. Reed's claims against the defendants. And again, he's kind of mixing what's in the 2 lawsuits here. These acts violated Ms. Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, a well-established Massachusetts tort principle. On June 18, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Ms. Reed was ultimately and finally acquitted of all charges relating to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Ms. Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, and this is how you really hook in when you get the higher ups. That's how you hook in MSP, town of Canton, potentially. Will we hear about the commissioner? There's a lot still to be determined. Here's the Noble quote. The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigating training, ensure appropriate oversight, and enhance accountability under my direction as Colonel. The state police has and will continue to improve these regards. In an Herald, Noble acknowledged systemic nature of MSP's conduct in Ms. Reed's case. I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Ms. Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. On March 19, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to Reed's investigation, the MSP trial board found Proctor guilty of a Class A violation, which included that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the MSP into disrepute. And that's directly connected with the investigation in this case, and that's so important because they get to use that throughout. They're going to argue it in trial, and it's an overarching dark cloud on this entire case. Ms. Reed's life was not merely turned upside down by MSPs and the House defendants' misconduct. It was forever changed by the House defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Ms. Reed seeks at minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Then we go into the parties and the jurisdiction, which we know all about. Now let's get to their facts common to all counts, starting with Mr. O'Keefe's death. Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28, 22, O'Keefe and Reed went out for the night. They went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There, they met up with a group of acquaintances, including Brian Albert, his wife Nicole, Brian's brother Chris, his wife Julie, Jennifer McCabe, Nicole's sister and Brian's sister-in-law, her husband Matthew McCabe, Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts home in Canton at 34 Fairview Road. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. Sorry, I just realized I'm looking the opposite screen, so I moved over here. Maybe that'll look more normal for you guys. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they didn't know each other well. Brian Albert and Brian Higgins were close friends. Higgins resided in Canton for many years. In January of 22 and was with the ATF. He also was permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor, as well as Brian Higgins. Higgins had been on a trip with both Brian and Kevin Albert in the days preceding January 29th. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house of Brian Jr.'s birthday, for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. As Miss Reed and Mr. O'Keefe had never been to the house before January 29, 2022, they arrived in front of the Alberts' home around 12:20 a.m. Ms. Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late night party. So again, we're getting into the mind a little bit more of Karen Reed. Her deposition hasn't been taken yet. She didn't take the stand in either of her criminal trials. So we're getting a lot of this that can only really come from Karen Reed, which is what happened when you dropped John O'Keefe off at 34 Fairview. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Again, how do we know that? Only from Karen Reed. Mr. O'Keefe walked toward the front door / garage door area of the house and entered one of the two doors. So again, there's some assumptions being made there, because if she saw him walk in the house, she would have seen which door he walked in, right? But based on all the circumstantial evidence, Reed's team is saying we know he went inside the house, either into the house or the garage. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed Mr. O'Keefe intended to stay, and therefore she left to go home without him. At some point after entering the house / garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. They're leaving open for interpretation. Will they be able to provide enough information to a jury to prove what exactly happened? Because you don't want to leave too many gaps for the jury to fill. Sure, it's a much lower bar than a criminal case, but they still have to prove what happened. During the altercation, the Alberts' German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating counter-coup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a rigid surface. The Alberts' garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backwards on a flat, cold lawn like the Alberts. Now, I'm confident there are going to be experts that disagree with this statement, but it's in a complaint, so we take it as true. Because of their knowledge of criminal investigations, the Alberts, the McCabe's, and the Higgins, meaning in parentheses, this is as a group, the House defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate, irreversible risk of their own criminal exposure. Therefore, at least 5 of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired that Mr. O'Keefe never entered the house and hide evidence that was there, including his body. So the dog bites and scratches and then falling on the back of your head, there doesn't have to be any criminal action there, right? Now, covering up a crime, lying to law enforcement, pushing evidence or lying and saying somebody else committed a crime, all of that, very problematic. But the very important thing is going to be the cuts and bruises to the front of John O'Keefe's face. That's what they are going to use to try and prove that physical altercation. And my guess is they're going to use the quote unquote sparring at the bar and on the CCTV footage and things like that. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passerbys. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the House defendants left him on the Alberts lawn, or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to the Camp Police Department in the middle of the night. He later told investigators that he had to do some quote-unquote administrative work, but then changed his story, subsequently stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm, even though he could have done that earlier in the evening when he was at the station to drop off Kevin Albert. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. Now, this stuff all looks bad. To me, this all stuff screams reasonable doubt. This is why I really didn't think the Commonwealth was close to proving it on either trial, but much more so on the second trial when the defense didn't go with this theory. But what does this prove? proves some shadiness. It proves some like, what the heck is going on? You've got some explaining to do. I'm going to ask you about this in your civil deposition. You know, if you were a lawyer on the case, like that's definitely something you want to dig into and see how inconsistent or problematic his answers are. But what are they actually going to be able to prove with this? Or are they just planning on proving a totality of the sus circumstances? After leaving the police station, Higgins and Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian, Albert, and Higgins denied the existence of these phone calls, and when confronted with their existence by a separate law enforcement agency at a separate proceeding, they coordinated the same exact lie, falsely claiming multiple calls, answers, and hangups were just butt dials. However, 5 minutes after the Higgins-Albert call, Mrs. McCabe performed a Google search on her phone at 2:27 a.m., How's long to die in the cold, misspelling the first word. So when you can put a timeline together and you can kind of explain it the way you want, like it's a closing argument or a complaint in a civil case, it does sound good for Karen Read. The timeline does sound bad for these House defendants. With exactly how all of the timing, you just happen to have these butt dials right before you just happen to open up your internet tab. Like, let's say, even if we're taking what they say, they happen to have these butt dials multiple times right before she opened this internet tab to, Google something else, not How's long to die in the cold. Miss Read searches for Mr. O'Keefe. Miss Read began the search for Mr. O'Keefe at 5 a.m. when she awoke and realized he had not returned home. She phoned House defendants Jennifer McCabe, who already knew exactly what happened to Mr. O'Keefe. McCabe insisted Read drive to McCabe's house rather than 34 Fairview, which Miss Read did. At the exact same time, Miss Read left Mr. O'Keefe's home at 5:07 a.m. McCabe took a 38-second phone call to her sister, Nicole Albert, at 34 Fairview. Nicole Albert said she was asleep until after 6 a.m., and Jennifer McCabe, when confronted with the call artifact at trial, claimed not to have any knowledge of the call. Ms. Read and McCabe were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, McCabe directed them back to Mr. O'Keefe's home, where Ms. Read had just come from. After the three of them finally drive to 34 Fairview, the illogical McCabe-based directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Albert's lawn and first responders arrived. So this really reminds me of trial number one, right? And in trial number one, they had some evidence of this. Now that we've had not one but two criminal trials, they have a lot more that they're going to be able to present as to how this not only looks fishy, this actually is evidence of a cover-up. I'm not so sure there's enough there to prove it, but I'm open to see what evidence they come up with. And of course, they're going to learn a lot more through discovery, through depositions. And there's a lot we don't know because we don't know what Karen Read's statement is going to be and how credible that is going to be to the jury. As they approached the house with Roberts driving, Miss Read saw Mr. O'Keefe almost immediately. She screamed for Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR, as the House defendants had planned. Mr. O'Keefe's body was discovered in front of the Alberts house near a flagpole and fire hydrant on the left side of the Alberts property. As seen from the roadside, the Ford Edge, which had been parked in the position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Roberts joined Read with administering CPR, McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that there's a man passed out in the snow. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, McCabe never went into the house or requested that Alberts come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. And these are the things that make you go, a guy is dead in their lawn. Could it have been an intruder? Could it have been somebody doing this on purpose? Maybe my family's in danger, especially when I called them and they didn't pick up. Or they could come out here and help me. None of that went through her mind. The investigation begins, okay? And this is where we're going to get into specificity and see what do they have against MSP, which is not in this complaint yet. What do they have against the town of Canton? How are they going to connect all this together? And you'll notice the more specific facts and the more in-depth factual allegations here. The CPD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There was no bone fractures or trauma in his lower body, his torso, or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason. The ranking CPD officer on the scene, Sergeant Michael Lank, opined on a telephone call to MSP Homicide, captured on dashcam audio, that Mr. O'Keefe looked like he had been in a fight. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn of 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn or in the roadway that morning, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulance, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's scream upon finding O'Keefe's body, no one from the Alberts house, including police officer Brian Albert, ever went outside to see what's happening, let alone help. They wanted to avoid scrutiny from the police investigation. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabe's pursuant to their plan. The Alberts and McCabe's told Sergeant Lank Mr. O'Keefe never entered the Alberts house. The night before, the Alberts and the McCabe statements were false. Mr. O'Keefe arrived and entered the house or garage where he was assaulted, attacked by Albert's dogs, and suffered a fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Lank nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death, nor did they request to search the occupants' cell phones, observe their bodies of evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabe's. After Sergeant Lank returned to the CPD, 3 hours after discovery of Mr. O'Keefe's body, and more than 2 hours after being interviewed at the Alberts home, that morning, Jennifer McCabe called Sergeant Lank to report that she recalled additional information except for this one call to Sergeant Lank. McCabe deleted from her phone evidence of all other phone calls she made and received on January 29th and just before 9 a.m. on January 28th and 29th. As part of the plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Miss Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, McCabe changed her story on this topic yet again. In furtherance of the House defendants' plan, McCabe then falsely reported Miss Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. The voice gets hit here. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Buchanan was Proctor's direct supervisor. Tully was the supervisory officer at the Norfolk County State Police Detective Unit, and thus supervised both Buchanan and Proctor. In their roles, Buchanan and Tully both knew at all times the extent of Proctor's misconduct investigating Mr. O'Keefe's death, as described below. From the beginning, Proctor should never have been assigned to the investigating officer, let alone a lead investigator. He grew up and resides in Canton, is good friends with the Alberts, and has known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before the O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister Courtney was also close friends of Julie and lived walking distance to the Alberts' home at 34 Fairview Road. That should have been an easy answer. He should never have been working on the case, but this is where we are. In fact, Proctor's own mother referenced the Alberts as a second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Buchanan Tully, in an effort to ensure that the House defendants were protected and that Miss Reed's rights to a fair investigation and trial were undermined. Proctor, Buchanan, and Tully engaged in a corrupt and biased investigation by not investigating inside the House and interviewing House defendants as friends rather than suspects. Proctor, Buchanan, and Tully and the MSP never searched for DNA evidence inside the House, never looked for rigid surfaces that could have caused a gash on Mr. O'Keefe's head, never inspected the House defendant's body for indication of bruises or cuts that resulted from an altercation, and did not search the House defendant's cell phones with the exception of Jennifer McCabe. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Okay? And again, in trial number 1, they tried to get into some of the marks on Colin Albert's hand. That's the only way he was involved in this, situation from the allegations from Karen Reed's team, and then not in the second trial. So they kind of abandoned that. He is not a defendant. They are not claiming he did anything as it results to this case. Proctor's, Buchanan's, and Tolley's interviews of the House defendants were outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, their lawyer's office, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants. And the House defendants took full advantage of it. So yeah, there is a lot of that, but it also feels a little bit to me like partly incompetence, because it seems like they screwed everything up. Specifically, Jennifer McCabe became the point person for all the House defendants in providing their false narrative to investigators and continued to serve in that role for years. She managed to communicate details about the House defendants' messaging and the investigation itself, including visiting Proctor and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. The defense is being very specific about exactly what they want to prove and what they think they're going to be able to do in this case with this case. McCabe was wildly active on her phone in the immediate aftermath of the House altercation that killed Mr. O'Keefe. Her cellular data reveals that she arrived back at her home at 12 Country Lane at 2:12:38 a.m. on January 29th. Her phone was unlocked at 2:23 and 2:31. Text messages were sent between 2:25 and 2:25:26, and 2 screenshots were deleted at 2:26:37. Her Apple Health recorded steps throughout the night after she arrived home at 2:14, 2:15, 2:16, 2:17, 2:18, 19, 21, 22, 23, 31, 33, 31, 33, 51, 351, 351. 18 calls were deleted between 5:33 a.m. and 8:50 a.m. and an outgoing call to Nicole Albert at 5:07 a.m. The last cellular artifact is particularly relevant because McCabe's call to her sister occurred 1 hour before John O'Keefe's body was discovered. Mere moments after a 43-second call at 5:05 in the morning, during which Reed and McCabe agreed to go searching for Mr. O'Keefe. Ring video from One Meadows shows Reed leaving the property at 5:07. So again, that's pretty damning. And there's so much, I try to think about this, if these people were arrested and handcuffed and the cops thought they did it and there was probable cause and prosecutors were saying, here's how I'm going to prove it with this circumstantial evidence, I think a lot of people would think it doesn't look good for them. Now, we know there's a lot of moving parts to this, and this is not a criminal prosecution. It's a much lower bar. But this stuff is really, really hard to explain, especially with some of the explanations that we've already been given that don't make a lot of sense. McCabe's coordination continued on February 1st, 2022, when she worked with another witness, Carrie Roberts, to draft a timeline in order to align their stories regarding what had occurred on January 29th. They did this in preparation for Roberts' interview with MSP, which occurred at the McCabe's residence despite MSP's protocol to separate witnesses when interviewed. While MSP interviewed Roberts, McCabe simultaneously texted her husband, Matthew McCabe, Nicole Albert, and Brian Albert, saying she is telling them everything, all the stuff. Nicole Albert responded, good, and call us after. 2 months later, after being prodded and influenced by McCabe and other House defendants, Roberts changed part of her story to better fit with Jennifer McCabe's own false statements. Specifically, Roberts testified falsely in a state grand jury proceeding on April 26, 2022, that she heard Miss Reed ask Ms. McCabe to Google hypothermia. She had not made this claim in any of the at least 3 interviews she gave MSP investigators in the days after Mr. O'Keefe's death, in part because it never happened. Carrie's new and false story to the state grand jury aligned exactly with McCabe's testimony that Miss Reed asked her to Google hypothermia. Reed even adopted McCabe's false claim that Reed had supposedly asked the question while praying in a CPD cruiser outside of 34 Fairview. Later, Roberts conceded that she never heard Reed ask McCabe to Google anything. She admitted this a year later in a separate proceeding on April 19, 23, conducted by a different law enforcement authority, not Proctor and MSP, and again during Reed's criminal retrial in 2025. So that's a big deal. And again, you see Carrie Roberts is not a defendant here because I think what the defense is going to try to prove is she was swept up in this and brainwashed and pulled onto their side and made mistakes, but she was not the ringleader, right? Clearly they're saying McCabe is the ringleader. But none of it happens without Proctor. If they're going to be able to prove it, it's got to be with Proctor. The House defendants deleted many of their texts among themselves and others in the aftermath of Mr. O'Keefe's death. The texts captured before deletion or recovered later also reveal some of the House defendants' planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister Nicole Albert that Carrie Roberts, who was present when O'Keefe's body was found, talked to the cops and kept it simple. Of course, there would be no reason to report back to other House defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Buchanan, and the MSP never sought the communications. Rather, they were obtained by Ms. Reed's defense attorney's repeated motions to compel access to data on Jennifer McCabe's phone. Later, in other group texts with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, "Ask Chris to ask some questions. Tell them the guy never went in the house." And that's the problem. The guy, right? That's what everybody's holding on to. Like, is that what you call your friend? As an endorsement of the plan, Brian Albert responded, "Exactly." Or agreeing to something he believed to be true, right? That's going to be the other side of this, but it's a complaint. So you read the facts as true. And if they file a motion to dismiss on this, which I assume they will, the judge is not going to throw it out because they're like, oh, this isn't true. That's just not how you can do it. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another quote-unquote separate law enforcement agency began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining some of the House defendants' phones, taking statements from the House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as the MSP's bias and corruption. So some people may say, well, then why aren't there criminal charges? Well, exactly kind of what I've been saying. It's very difficult to prove. And with the horrible investigation and the destruction of some of the cell phones on military bases, it'd be hard for the FBI to maybe prove this. Karen Reed's team thinks they can prove it in civil court, and they have a right to do that as private lawyers. But as private lawyers, we don't have the right to file criminal charges. So even if Karen Reed wanted criminal charges to come against any of these people, it's not her decision, and the FBI has declined to do so at this point. Proctor and Buchanan initially reviewed that the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. However, Jennifer McCabe's cell phone location data shows that she was at 34 Fairview all morning, leaving at 11:15, just in time to meet Proctor at 12 Country Lane at 11:30. According to Proctor, he was at CPD just a mile from 34 Fairview before proceeding to the McCabe's home for their scheduled interview. At that point, Proctor had still not inspected 34 Fairview and had not interviewed either McCabe's or Albert's. He could have done both simply by driving a mile to 34 Fairview, where both the McCabe's and the Alberts were minutes earlier, rather than drive across town minutes later in a snowstorm. He did this intentionally to avoid 34 Fairview, where he would have been required to inspect the house and property and make reportable observations. He also wanted to make the McCabe's and Alberts more comfortable for their interviews. Buchanan and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd, 2022, did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Mr. Reed was arrested and charged, and did not interview Colin Albert, Brian Albert Jr. until September 15, 23, nearly 2 years later. And even if they had anything important to say, it's really hard to remember something for the very first time when you're being asked about it 2 years later. Before both interviews, the McCabe's and Alberts continued to coordinate their stories as evidence in group text. Proctor, Buchanan, and Tolley likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchanan interviewed Higgins on February 3rd at Higgins' attorney's home in Sharon, Massachusetts, Higgins presented the troopers with a select set of self-curated texts between himself and Ms. Reed. They learned that Higgins and Ms. Reed had been exchanging flirtatious texts and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully refused to investigate the matter further. They never interviewed Higgins again, even after the surveillance video revealed Higgins was suspiciously hiding his face in the halls and in the parking lot of CPD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag he was carrying in the video, but they went so far as to hide this video from Ms. Reed and her criminal defense attorney for years. Ms. Reed's defense did not receive these videos until after she stood for her first trial. That's the point. It's like so much changed since the first trial, which is when they originally went with this theory. And even after the separate law enforcement agencies' investigation revealed late night phone calls between Brian Albert and Brian Higgins, MSP failed to produce either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. This concerted inaction by MSP, Proctor, Buchanan, and Tully directly benefited the House defendants, especially Higgins and Brian Albert, who proceeded to dispose of and destroy their phones, just as criminal court ordered them preserved in response to a motion Reed's criminal defense team. Specifically, on September 15th, Ms. Reed's defense attorneys filed a motion requesting that the court order Brian, Albert, and Higgins to preserve the contents of their phones. A Superior Court judge held a hearing on that motion on September 22nd and announced in open court that the defendants were required to preserve their phones, signing a preservation letter to that effect on September 23rd. Higgins was served with a copy of the court's order on September 30th. He later testified that he changed phones and mobile carriers on September 29th. Later, in October of 22, Higgins then destroyed his old phone, which was the subject to a court's preservation letter. In fact, Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with the scissors he brought with him, and destroy and dispose of the phone and card in two separate dumpsters before driving back home. Brian Albert received a copy of the preservation letter sometime between September 23rd and 24th. He originally testified that he threw away his phone the third week of September 22, but then later claimed that he did so on September 22nd, one day before being notified of the court's order, and the same day Ms. Reed's defense attorneys argued in open court that the phone should be preserved. Coincidence? He just so happened to plan that day to go to the military base and throw away his phone. Like, you can see how these dots start to get connected. Higgins and Albert's destruction of their phones eliminated potentially incriminating communication between them and was a direct result of Proctor's, Buchanan's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records or simply interviewing Higgins and Albert to inquire about the nature of the late-night communications. They intentionally ignored these avenues as well. So we saw, I think it was Corey Richard's case, where like they had another person that might have been a good witness for the defense, and the investigators had a reason not to believe them or not to go down that route. So law enforcement does not have to interview everybody just because the defense says they do. But if there's enough evidence, if there's something that could be another legitimate lead, they should. These are arguments of a lack of or bad investigation. These are arguments to create reasonable doubt. Flipping them to be arguments of conspiracy and cover-up can be very, very difficult. And so the depositions of these people, one of the most difficult things I think for the Alberts and Higgins of the world is going to be keeping their stories straight and not saying things that are going to get them impeached, make them look worse, make the timelines worse, or be something that Karen Reed's team has absolute evidence is not true. That's something to keep an eye out for in the civil litigation. Not only did Proctor fail to probe his friends' stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instead instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. So they say this a little more matter of fact than I think it might come out. But when you have to prove a conspiracy like this with so many people, A, it's obviously going to be difficult. B, you're going to have to reach a little. You're going to have to see things where it may be difficult to see something in a certain text or a comment. And that's why they're gathering everything they can and they're putting it into this 54 pages. But the world of knowledge that they have, I'll just tell you this right now in a civil litigation, the world of knowledge Karen Reed's team has right now is a percentage of what they're going to have when they're done with discovery. A percentage of what they're going to have when they're done with depositions. Because the rules are different. It's much more open now. Proctor shared investigatory details with Courtney before they were public. In the same instance she referenced above, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then, after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He protected them and treated them like the family friends that they were. At one point, leading up to some of the interviews, Jennifer McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn from Julie Albert, again, through Courtney, Nicole Albert responded, "We'll get more info tomorrow. Don't want to text about it." Why would they not want to text about it? Like, what would they be worried about? Right? I mean, those are the kinds of questions that keep popping up in my head. House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. Obviously, that's Reed's position, but I wonder what they're going to say. Why didn't you want to text about that? For instance, because that's going to be asked in a depo. It was discovered in the second criminal trial that Jennifer McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Lank's house. However, while they did not text about that meeting, McCabe's cell phone location data obtained later by Miss Reed's defense reveals that she did in fact visit 34 Fairview just one day after O'Keefe's death and lied about it. Again, this cellular evidence and the deception by McCabe was never investigated further by MSP, despite the fact that they had McCabe's full phone extraction since February of 2022. Yeah, I mean, they were not looking into any connections between the McCabes, the Alberts, and law enforcement. McCabe's, Alberts, and Higgins all told similar false stories to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. For example, Higgins testified before the state grand jury on April 28, 22, that he parked his Jeep Wrangler in front of 34 Fairview Road for the duration of his stay on January 29, 2022. However, none of the other House defendants or the precipient witnesses who parked briefly out front of around 12:30 a.m., Nagel, Maxon, or Diatono, ever testified about seeing any other vehicle parked there other than Miss Reed's Lexus. Matt McCabe claims to have seen V-shaped tire tracks in the snow, another observation not corroborated by any other witnesses. Further, Brian and Nicole Albert initially told Lank of CPD that their daughter, Caitlin Albert, left the house that night around 12:15 when she was picked up by her boyfriend. However, when Caitlin Albert and Brian Albert Jr. were interviewed on August of 23, they both testified that Caitlin was the last person to leave 34 Fairview approximately 1:45 a.m. Brian and Nicole clearly made efforts to exclude placing their eldest daughter in the house when Mr. O'Keefe was there. Neither Proctor, Buchanan, Tully, Lank, MSP, or CPD ever further investigated this 90-minute discrepancy regarding the presence of a key witness in the alleged murder. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP coordinate with the House defendants to target Karen Reed. Instead of taking the routine, objective, and necessary steps of investigating McCabe's, Higgins, and Alberts, Proctor, Buchanan, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later. Before reviewing any surveillance from the bars, ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, though the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends the evening of January 29th the day he began his investigation. He told them MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death. even though the MSP had not at that point visited the crime scene or been inside the Alberts' home and had performed only cursory interview of the McCabe's and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike. But he did have injuries consistent with a fight and dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property where Mr. O'Keefe's body was found, would receive some crap. Instead, agreeing with another friend's assumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Miss Reed and she was effed. And there was zero chance she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's and all of those text messages are what give reference to the pin it on the girl. That's what Proctor was saying in those text messages. That's what the totality of them basically were to put forward on Karen Reed's argument. That's her argument, is that he was going to pin it on the girl. That's what the text messages said, right? That's the bulk of the text message, or the point, or the motive behind the text messages, which I agree with. I think that's exactly what those text messages say and sound like to me. If you disagree with the way that's what they read, that's fine with me. Two people can read the same set of text messages and say, no, he wasn't saying they were trying to pin it on her at all. That's fine. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Buchanan and the other MSP troopers show Proctor had decided to focus suspicion on Miss Reed to the exclusion of everyone else. Focusing on Miss Reed is not that big of a deal. That's normal. That's the person that starts on the inner circle, right? The significant other. But to completely ignore any other leads and potential defendants, that's the problem. That's the problem. And that's what makes it look like a conspiracy and cover-up, according to Karen Reed's team. He told the troopers that Miss Reed was, again, the R word, and that he was searching her phone for nudes of her. In the text chain, Buchanan liked Proctor's text describing Miss Reed as that. Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. And that was frowned upon. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred in his quest to charge Miss Reed, and later admitted the medical examiner's refusal to rule the death as a homicide did not matter to him, because either way, Miss Reed was going to get charged. Totality of the text messages. In those circumstances, that's exactly what it looked like Proctor was going to do, right? To make sure of it. He was going to make sure of it. And that could happen a couple different ways, right? That could happen because he really thought it was her, so he wanted to make sure that all this gets pinned on Karen Reed because he thinks she did it. Or a more nefarious explanation might be he wants to protect his friends. Or he already said this stuff and he already started going down this road. Now he wanted to make sure he was right. Because how embarrassing would that be if I arrested the wrong person and did all this to the wrong person? Cops have done that in the past. Proctor and Buchanan plant certain evidence and make false statements in court and other legal documents to frame Karen Reed. Okay, this is bombastic. I mean, these are big swings by Karen Reed's team. Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP's policy and well-established best practices for critical incident investigation. Especially, the MSP Crime Lab requires proper processing of evidence at major crime scenes, including the crime scene photography and evidence processing, and recovery of latent fingerprints, footwear, and tire track evidence. Neither MSP troopers involved in the investigation nor CPD police officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where Mr. O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside of the garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanan to generate false incriminating evidence against Ms. Reed and give the House defendants time to destroy actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Ms. Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17, the vehicle was in MSP's physical possession. The vehicle was then towed to CPD Sallyport, even though the MSP had at least 2 closer barracks, including Middleborough, the MSP headquarters for accident reconstruction, and where the vehicle would ultimately reside for analysis. And Massachusetts was in the middle of a historic nor'easter. So why? Why did they choose the Sallyport? Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP's facility, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview. So if and when MSP gets brought in or filed a lawsuit against them, this is why it's negligent hiring, training, and retention, and not that they're in on the conspiracy, because they even admit here, this may have been harder for Proctor if he would have done this in their facility. Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack but was intact. An observation ultimately made by Dighton officer Nicholas Barros, who was never interviewed by Proctor or any member of MSP. I mean, it's every time we dig into this case, it boggles my mind more. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning when she was leaving to search for him. Even if you don't believe that, even if you think that's BS, even if you believe the Commonwealth's experts where they say it's impossible that happened, what do you do with Barros? Is he also lying? Why didn't they talk to him? Why didn't the Commonwealth call him? Buchanan and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear taillight was almost entirely destroyed. Video taken from different angles of the Sallyport showed Buchanan, Proctor, Camp Police Chief Ken Berkowitz, and other individuals near the taillight. But notably, no video captures the taillight appearance at the precise time when it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD access card swipe log obtained by a separate law enforcement agency, reveals seemingly unfettered access to the Sallyport by a myriad of individuals, including Brian Higgins, throughout the evening of January 29th, including just before and just after 5:30 p.m. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then placed some of them at various places at 34 Fairview on Mr. O'Keefe's clothes. Big allegations. Big allegations. How do you prove that? Well, it could go something like, there were no taillight pieces in the yard. You get access to the vehicle. There's glitches, timestamps, jumps when the vehicle's in your possession. Nobody can really confirm what the taillight was, looking like when it showed up at Sallyport. Barrow says the taillight was fine when they left. Karen Reed, her car is showing, if you want to use that, bumping into John O'Keefe's car. No taillight on the lawn, though. That's the important part. That's the first thing where it's kind of like in a case when you're trying to show when an injury started. No pain prior to the car accident. You get in the car accident, now you have pain, you need surgery. No taillight pieces in the yard, you get access to the light, now there's taillight pieces in the yard. Because I don't think they're going to get any evidence of, actually seeing Proctor crack the taillight, or, somebody saying, yeah, I saw Proctor take a hammer to the taillight. I don't think they're going to get that. So it's going to have to be kind of totality of the circumstances with circumstantial evidence. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Buchanan worked together to obscure their role in manipulating the right rear taillight and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from the surveillance cameras located both inside and outside the Sallyport garage, which he did. Those videos were manipulated in 2 significant ways. First, a crucial 42-minute portion was deleted from the footage from the Sallyport front wall camera. The portion from 5:08 to 5:50, which included the exact time Miss Reed's Lexus arrived in the garage and the period Proctor was at the passenger side taillight. So I don't know, did they prove that was deleted, or is that where the jump? It was motion censored. I can't remember if they proved the deletion. This footage would have shown that the taillight was intact. Second footage from the Sallyport back wall camera was inverted, which was made the right side of the vehicle look like the left side of the vehicle and vice versa. Another camera, the main driveway side exterior, captured the back end of the taillight as it arrived to CPD, but was too grainy to decipher the condition of the passenger taillight. The video from inside and outside the Sallyport and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. And again, some of this is going to be on the DA, right, who is not involved in this, but who's turning stuff over when and when do they know about it? We'll see who points fingers at who. In fact, Buchanan presented one of the videos during his direct testimony to Adam Lally. Buchanan narrated the video to the jury, correctly identified Proctor was at the rear of the vehicle, but claimed he never saw him approach the rear right taillight. That testimony, however, was entirely false. As we know, the video Buchanan authenticated as fair and accurate was neither fair nor accurate because it was inverted. Proctor was actually behind the right taillight for a significant period of time. Because it was inverted, it appeared in the video that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. With the video and Buchanan's false testimony, MSP and Proctor and Buchanan attempted to mislead the jury in order to conceal the tampering with planting of taillight material. So I will always try to do my best, but I will ask for grace when I screw up. This could be a scenario where it was just a mistake, the inverted video. But the level to which they went down the road to use the inversion to prove a fact, I think makes it more difficult. And then when called out on the mistake to still try to double down and not make it seem like it looked like what it was, that's also an issue, right? If they would have just been like, oh, I'm sorry, yes, he was behind that taillight for a long period of time where, none of us could really see him, but they still tried to kind of wiggle there a bit. Proctor and Buchanan took taillight pieces from the Sallyport, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. In warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of the Google electronic records, ring videos, Miss Reed's phone, Miss Reed's vehicle, cell towers, and other sources of information, Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29th and had the vehicle towed to CPD. Reports shared by the Dighton Police Department reveal the Lexus was towed from Dighton at 4:17. Proctor's assertion that he seized it at 5:30 was intentionally false to hide the fact that he was in the custody of the car. The car was in police custody, for 73 minutes longer than indicated in his sworn affidavits. I don't think that would have mattered, in my opinion, on the sworn affidavits, but it's a good inconsistency now for what Karen Reed's trying to prove. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Miss Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed, so it's others who all's involved, we don't know, from the vehicle in the Sallyport onto Mr. O'Keefe's clothes. Proctor retrieved from Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buchanan drove them around in his car all day and placed them in a Norfolk County DA's office for at least 6 days where they were accessible to Proctor, Buchanan, and other MSP troopers. In his trial testimony, Buchanan asserted that both he and Proctor were at the Norfolk DA's office drying out O'Keefe's clothes on butcher paper. Well into the evening, at least 8:30 p.m. on January 29th. But in front of MSP's trial board in March of 25, Proctor testified he arrived back at home at 7 o'clock at night. Furthermore, there's going to be stuff like that where more is going to come out, and more has already come out with this complaint. Proctor stated that he went from a debrief at CPD straight home and never mentioned visiting the NDAO with Buchanan and handling items of evidence, despite Buchanan's claims that Proctor was handling the clothing that night. On these matters, Buchanan and Proctor's sworn statements significantly differ and cannot both be true. Proctor and Buchanan also failed to create a log and document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, or under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with the clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collectors seal evidence package as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. I mean, they're going to have so many policies and procedures that just were not handled right. I mean, right? We can all probably agree with that. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14th, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP crime lab. At some point before providing those clothes to the crime lab, Proctor and/or Buchanan placed pieces of taillight on them, where they were then identified by the crime lab in 2023. The cross-contamination of bags and who's gathering things and where it is, this is plausible. It's possible. Will it be able to be proven in civil court? What evidence will they have of it other than it wasn't there and then it was there? Proctor also planted pieces of glass on the bumper of Miss Reed's SUV while it was in the possession of CPD's Sallyport garage, which he then claimed to have recovered later on February 1st. So this is where it's a big problem for Proctor, right? Because during the trial, this is where Alan Jackson had the graph, the chart. And I was like, man, what other explanation is there besides Proctor planting this? This was a really tough one for me, who tries to give everybody, even Michael Proctor, the benefit of the doubt and as much grace as I possibly can. I found this to be nearly impossible to give him grace on this. It looks so bad. It looks like a duck, right? If it quacks like a duck, walks like a duck, talks like a duck. Proctor planted the evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding while he exited the Waterfall bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass. Which again, if you think about that, those little shards of glass, sometimes you don't test those. Those aren't tested in every single case. Thank God they were here. Which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. So where did they come from? In fact, the 5 glass pieces originated from multiple different sources. One shred of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. It's like the Proctor glass. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Other aspects of the conflicted and corrupt investigation. Proctor's, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other members of the Albert family about the presence of video monitoring. Proctor and the MSP also failed to track down other important witnesses, evidence, for example, Brian Lothran, Lucky, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire trial. Proctor and his colleagues never spoke to him during the investigation and only did so once Lothran was interviewed by a separate law enforcement agency and provided statements inconsistent with the MSP's narrative 18 months after Reed was already indicted and awaiting trial. And again, I want to continue to remember to look at this differently. Look at it differently than a criminal investigation. Then how could they not do this? This shows reasonable doubt. Now, Karen Reed's team, before in a criminal trial, it didn't matter whether they did it on purpose or whether it was complete negligence. It created reasonable doubt. It showed signs of reasonable doubt. But now, it needs to be more intentional, right? Because they're saying this is a big conspiracy, a big cover-up. They intentionally went after Miss Reed and disregarded anything that didn't have to do with her because they were trying to cover up the crimes that the House defendants committed. That's what they're trying to prove here. So now you have to prove this was intentional, not that a reasonable officer would say, I'm not going to believe Lucky. It's too inconsistent. It doesn't make any sense. Because if a reasonable officer would disregard his testimony, that's a good argument for the House defendants or for the law enforcement defendants. Specifically, Mr. Loughlin drove his snowplow by the house multiple times in the early morning hours of January 29th, including 2:30 and 3:30 a.m. He reported that there was nobody on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Loughlin believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Mr. Loughlin saw a Ford Edge in front of the Alberts home that had been there an hour before. What's interesting, too, is if he just made up the Ford Edge or, got lucky that it's also in their house, no pun intended with his name, but that it's also in their household that people that were there happen to have Ford Edges. To me, there's just too much to be a coincidence. But which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time. However, the Ford Edge was gone by the time Ms. Reed arrived at the house at 6 a.m., and in its place, she discovered Mr. O'Keefe's body. Proctor, Buchanan, and Tully never made any effort during the actual investigation to track down Mr. Loughlin or any information relating to the Ford Edge. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present in the house the night of January 28th and 29th, but Proctor omitted his name from his original official summary of Miss Nagel's interview, even though he listed all others who had been present at the house with Colin. When Ms. Reed's attorneys filed the motion to obtain Proctor's notes, his handwritten memorialization of Julie Nagel's interview mirrored almost exactly what was typed in his police report, except for the words Colin Albert. Again, has to be intentional. Proctor's interactions with Kevin Albert during the investigation also demonstrate his close relationships with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin instead of official channels when he coordinated interviews of witnesses, even though CPD was recused from the investigation. On January 30th, 2022, Kevin Albert texted Proctor on Proctor's personal cell to coordinate Proctor's use of CPD facilities to interview witnesses and about what witnesses Proctor planned to interview and when. Tellingly, despite the fact that he was investigating the murder of a law enforcement officer and that MSP rules and regulations require recorded witnesses and suspect interviews when possible, Proctor never used the recorded interview room at the CPD and instead chose to keep the interviews offline and do them at friends' house, at lawyers' offices, all these different things, right? That's what he decided to do. Further, in the middle of Proctor's investigation in the summer of 22, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. Now, what is this really supposed to prove except for maybe the family connection and how close Proctor was to them? Because this doesn't necessarily prove anything after the fact because this happened in the summer of 22, but obviously bad for them. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated MSP policies, as well as various Massachusetts criminal statutes, and further highlights the conflicted nature of MSP's investigation. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MSP and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for her first trial. Those videos captured Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. These videos demonstrate that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Ms. Reed. Those are serious allegations. Like, imagine being a criminal defendant there or a criminal defense lawyer there. Additionally, upon information and belief, CPD, those are people that should really be interested in this case and see what happens. And hopefully if there's corruptions and cover up, that it all comes to light, not just by allegations or people saying it online, but actually proof in court. More so than what we've seen, because again, different angles. I don't blame Karen Reed's team. I think it was the right thing to do to switch it to the reasonable doubt for trial 2 to get that win. And now you lay it on thick to really prove what you're saying here in court. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos from the Sally Port to 30 days, therefore assuring immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPT videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent the defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and withheld from defense. That's hard to argue against too. Either at some point during this one of these two things has to be true. Either at some point in the middle of this criminal investigation, they changed it to 30-day auto-delete, or within 30 days of January 29th, they had all of this and they didn't even turn over some until after a trial had already been done. Not good. Not good. The indictments, trials, and aftermath. Ms. Reed was arrested on February 1st, pursuant to a criminal complaint charging her with manslaughter. Among other charges, she was required to pay $50,000 for bail, and the court imposed several other conditions of release, including the loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Ms. Reed was later rearrested on June 9th after being indicted on a second-degree murder, manslaughter, and leaving the scene of the accident, resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 23, her bail was reduced to $80,000 at the defense's request. Ms. Reed was tried twice by the Commonwealth. First trial in April of 24 ended on July 1st after the court ordered a mistrial because of a hung jury. On June 18, 25, following nearly a 2-month trial, Ms. Reed was acquitted of all charges associated with the death of John O'Keefe. Karen Reed was able to leave, for the first time in 3.5 years, Karen Reed was able to leave the court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January of 2022, the defendant's actions have had a profound effect on Ms. Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car, her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees, and additionally, an additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be in prison for the rest of her natural life for a crime she did not commit. For anybody that's ever dealt with any hate or problems or people talking about you, whether it's in your group of friends, in your circle, in your community, or online, you can imagine that's stressful. That's not great. You wish that wouldn't happen. Even people with thick skin, right? Sometimes it's impossible to just completely ignore a lot of different people talking about you because we are human beings. Imagine what that has been like for Karen Reed, for somebody that has been acquitted. These crimes were not proven in a court of law. And many of the jurors believe she's factually innocent. And she had to go through all that for all these years. Honestly, anytime, something bad happens in any of our lives, you look around, you're thankful for the good things in your life. You're thankful for the tests you've not been put through. But when you see other people who have, you can sympathize with them and empathize with them. And I think that if this were to come before a jury, if they can get them to believe the facts, even to a reasonable degree, to get to 50.1%, they are going to feel the pain that Karen Reed suffered. I truly believe that. Ms. Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with criminal courts, Ms. Reed has undergone tens of surgeries to manage her illness prior to January 29th and endured a blood infusion just months before Mr. O'Keefe's death. In the aftermath of the charges, 2 arrests, and both trials, Ms. Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against the corrupt prosecution, Ms. Reed underwent dozens upon dozens of documented medical procedures and treatments to address her health issues. The defendant concocted a plan, executed that plan, and framed an innocent woman, and they now are responsible for these extraordinary damages Ms. Reed has suffered at their hands. All right. John is coming to save the day, to save my voice, to read the last, 15 to 20 pages of this complaint, including the causes of action, which will be important when we get there to see, especially for the town of Canton, why they were added to this amended lawsuit. So, go ahead, John. Let's start at the top of page 36.
36. The House defendants and investigators continue to lie and manufacture evidence and coordinate and conspire together years later. The House defendants continued to execute on their strategy of misdirection and dishonesty for years after Mr. O'Keefe's death. For example, on April 10th, 2023, 2 agents from a separate law enforcement agency made an unannounced visit to Jennifer McCabe at her home. She initially lied to these agents when she answered the door, saying this was Nicole Albert. She then asked the agents to wait 10 minutes while she got ready. Afterwards, when asked by the agents, McCabe first told them she had called her husband, House defendant Matthew McCabe, and Carrie Roberts. But after the separate law enforcement agency agents warned her of the penalties for lying to federal officers, McCabe then revealed that she had also contacted John O'Keefe's mother, the NDAO, and Brian Albert. McCabe made sure to warn other House defendants immediately, like Brian Albert and Matthew McCabe, that another agency was asking questions.
All right,
the coordination.
So again, anytime I get thrown into the Karen Reed world and I'm reminded about, these kinds of factual allegations and we read them together, we cannot just gloss over how wild that is, that she lied about who she was. She very clear. And it's like, if you've already, told the truth and told your story and talked to multiple law enforcement agencies, why would you feel the need to lie here? These are going to be the things that make them look so horribly bad, which again, a lot of defendants in a lot of cases that do stuff like this, that's used against them. They look really bad when that's done. And there's just more of that here than there should be for just your everyday civilian witnesses. I'm sorry, it is. I mean, it looks so bad. I don't want to accuse somebody of things they didn't do, but she admitted to these problematic interactions with federal law enforcement agencies or agents, and it looks really bad. All right, you can continue.
McCabe made sure to warn other House defendants immediately, like Brian Albert and Matthew McCabe, that another agency was asking questions. The coordination between the House defendants and MSP, Proctor, Buchanan, and Tully, was also not short lived. For example, in the evening of September 25th, 2023, McCabe visited Proctor's house. This visit by a key witness in a murder case to the home of the lead investigatory is not explained or even acknowledged or mentioned in any MSP report. In fact, Reed's criminal defense team only learned of McCabe's visit to Proctor's house when a photo of her Jeep was publicized. Furthermore, in 2024, on the eve of Miss Reed's first trial, Miss Reed's team learned that McCabe had visited CPD Sergeant Michael Lank, who was the ranking CPD officer on scene on January 29th, at his personal residence at 5:43 p.m. on January 30th, 2022, and stayed until 6:28 p.m. It was only after Miss Reed's attorneys shared this data with the Commonwealth, 2 weeks before McCabe's trial testimony, that Tully met with members of the NDAO and McCabe to discuss her visit to Sergeant Lang's home. Neither Tully, Proctor, nor any other trooper memorialized this meeting or McCabe's visit to Sergeant Lang's home. Furthermore, McCabe later testified on May 21st, 2024, that she went straight to Sergeant Lang's house from One Meadows on January 30th, but her cellular data shows that too was false. McCabe's phone shows she stopped at 34 Fairview Road from 5:36 p.m. to 5:40 p.m. And even after this case was filed, some of the investigators have continued to coordinate and work with the House defendants. For example, in the fall of 2025, defendant Buchanan repeatedly fundraised for the House defendants on social media sites. He urged support for the House defendants against Miss Reed's evil, chaos, and lunacy.
All right. So real quick, these are the types of things, again, that during a criminal case might not go as highly scrutinized, like, okay, I didn't do a report, sorry, maybe it's reasonable doubt. 2, you did all these reports, but you chose not to do one here. And look who it happens to connect with, Jen McCabe. And that's where you start to get the conspiracy. They're all putting it together. And Karen Reed's team is just going to stack all of this stuff on top of each other in this civil case to show this was not coincidence. This was not just pure negligence. This was intentional. This was a conspiracy. This was a cover-up. And they're still continuing to help each other with Buchanan on the social media sites. All of these people involved in this lawsuit, if they did nothing wrong, if they truly did nothing wrong, I feel horrible for them and what they're going through. I do. Because they did so many things that just look so bad, maybe not even in isolation, but when all taken together, and it just is creating a picture where it's like, this just can't happen. You can't be this incompetent as law enforcement, in my opinion. It's so bad that it does almost feel like it's intentional, right? I mean, that's the vibe that I get when I think about so much of what went on in this investigation in this case.
MSP investigates and punishes Proctor, Buchanan, and Tully for their misconduct during the investigation.
Sorry.
Proctor wrote more than...
I know I'm interrupting a lot, but
Sure.
But when we talk about cops being like, oh no, I didn't have to go and talk to Lucky Laughlin, or, I didn't find him credible, or this is normal police behavior not to record this or not to put this in a report. Well, when they start to hear that these lead investigators and supervisors got punished for their work on this case, a civil jury is not just going to give cops the benefit of the doubt, or former troopers the benefit of the doubt that they get a lot in criminal cases. So it's going to look very different in this trial, if we get there, of course. Okay, now go ahead.
Proctor wrote more than 1/3 of the police reports in this case, testified to the state grand jury 3 separate times, interviewed every member of the Albert and McCabe families, had possession, at least until March 14th, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevrolet Traverse the day after Miss Reed was arraigned, had access to and reviewed all of the ring videos, had access to and reviewed the surveillance from CF McCarthy's, had possession of all of the CPD Sallyport and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide from the jury and sanitize the compromised investigation, while Miss Reed was forced to trial not once but twice. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7th, 2024, mere days after the conclusion of Miss Reed's first trial. Proctor was terminated from the MSP on March 19th, 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone on October 18th, 2025, Proctor officially withdrew his appeal with the Civil Service Commission.
Yeah, what's crazy about this too is some of this, not all, I don't think all of this is going to come into the civil trial, but these are going to be legitimate facts that Karen Reed's team gets to argue in front of a jury. I mean, they didn't even call him in the trial. He got fired right after trial one. I mean, it's just going to be, it's going to look, I mean, I don't know how many cops have looked worse in a trial, that cops that have not committed crimes, right? There's obviously cops who commit crimes, get arrested and all that. But it's like, just for your work on a case to be this just publicly dragged out is brutal.
On September 23rd, 2024, an MSP internal affairs investigation found Yuri Buchanan failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Buchanan was transferred out of the NDAO detective unit and reassigned to an administrative role in another division. On October 18th, 2024, Brian Tully was disciplined and reassigned from the SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case, despite his demotion because of his behavior on this case. Upon information and belief, MSP troopers David Dicaro and Jeffrey DeCiccio and Jeffrey Kutkowski were also disciplined for their misconduct associated with MSP's investigation of Miss Reed. Nearly every instance of such discipline in Proctor's unit occurred before this case was even fully adjudicated in the second trial. Proctor himself admitted to a trial board in March of 2025 that he informed his superiors, Buchanan, Fanning, and Tully, in February of 2024, before the first trial, that he had testified before a berating U.S. attorney regarding the prejudicial messages on his phone in his relationship with the Alberts. Nevertheless, no member in Proctor's chain of command or in the MSP sought to discipline these individuals until after Miss Reed stood trial. Counts.
Okay, now we get into the causes of action here. You can, by the way, for every single one of these counts, you can read what the count is and then skip the first paragraph because it's all just saying that all the prior paragraphs are incorporated by reference.
I'm sorry, I don't know what you mean by first paragraph.
Like 143, you see how that says the preceding paragraphs are incorporated herein by reference. Mm-hmm. Every single count is going to have that same paragraph, so you can just skip that one.
Okay, gotcha. Malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. Proctor, Buchanan, and Tully violated Miss Reed's Fourth Amendment rights by engaging in a malicious prosecution of Miss Reed by causing her to be seized pursuant to legal process unsupported by probable cause.
Okay, hold
on. The criminal proceed.
So the important thing is unsupported by probable cause. And in order to defend against this, you can start to try and prove, and this is like all this burden shifting in this, that you actually did have probable cause, or they believed they have probable cause. And one way you can prove that is with a grand jury, with a judge, with witnesses, with other law enforcement. Like all of these people were on the same page about probable cause. But did you lie, cheat, steal, and plant evidence to get there? Because if you did, then they gave you probable cause because you planted evidence, so it's not real probable cause. So it's going to be a lot of moving parts when they're trying to prove things like this.
The criminal proceedings against Miss Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buchanan, and Tully caused Miss Reed to be seized without probable cause as described above, including, but not limited to, by leading, handling, and participating in the O'Keefe's investigation, even though Proctor was conflicted due to a personal relationship with various witnesses, suspects, and potential suspects, which conflict led to Miss Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme personal negative bias towards Karen Reed, which bias led to Miss Reed's unlawful treatment. Violating MSP's rules, policies, and procedures in all aspects of the investigation. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Failing to...
There's a difference, right, between failing to do things and negligently doing things versus planting, fabricating, manipulating, falsifying, committing perjury, right? These are going to be mega, mega swings at Proctor. That, I mean, this is his worst nightmare. I would not want to be him with this impending civil litigation.
Failing to secure evidence in the crime scene, obtain evidence timely and appropriately, interview suspects, and investigate the Alberts, McCabe's, or Higgins, and allowing them to destroy potentially exculpatory evidence. Failing to consider the present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of a lower body trauma. Following her indictment by a grand jury, Ms. Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continued during Ms. Reed's second trial, in part because of Proctor's false testimony at Ms. Reed's first trial. Among other things, Proctor falsely testified that when he first saw the taillight on Miss Reed's car at Miss Reed's parents' house in Dighton, it had large pieces missing and shattered taillight displayed at the first trial, as photographed on February 1st, 2022, was in the same condition as on January 29th. He and Buchanan never touched any part of Miss Reed's vehicle when it was stored in the CPD Sallyport. He retrieved taillight pieces on subsequent searches at the Alberts' home when he knew he had deposited and arranged for someone to deposit taillight pieces at the property. Chris and Julie Albert were his loose acquaintances rather than friends, and his statements in sworn affidavits, all claiming the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were typos. Thus, Proctor, Buchanan, and Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 USC 1988, cost, interest, and punitive damages. 1983, supervisor liability against Buchanan and Tully in their individual practices.
Yeah, real quick on the malicious prosecution. This is a lot harder to prove than people may think. I know a lot of people in the public think this is exactly what happened to Karen Reed. And I think the publicity and all the push behind it is good for them and maybe put pressure on a settlement. Obviously, we know they're not scared to go to trial on something like this, but it is more difficult to prove. And there's a lot of technicalities that will come out and really be best shown at trial. But the discovery is going to be, the huge part of all of these civil actions and what's going to cross over one to the next. What are we going to hear about publicly? What are we not? That's going to be, to me, the biggest part about it. But let's go ahead and read through all of the counts just so we can know exactly what they're going for here.
Count 2, supervisor liability against Buchanan and Tully in their individual capacities. A supervisor is liable under 42 USC 1983 when the supervisor supervises, trains, or hires a subordinate with a deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts with whom he had a close personal relationship, which he had disclosed. They also knew or should have known that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. Buchanan and Tully could have taken easily available steps to avoid a constitutionally deficient malicious prosecution of Miss Reed. Those measures include, but are not limited to, first, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. 2, safeguarding the crime scene with the physical evidence including Mr. O'Keefe's clothing and 47 pieces of taillight material and 19 pieces of glass from various sources to prevent anyone from planting, manufacturing, or manipulating evidence. 3. Initiating timely searches at the Alberts house. And 4. Quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, the McCabe's, and Higgins, which would have prevented their later manipulation and destruction. By not taking any of those measures, Buchanan and Tully permitted Proctor and Tully permitted Buchanan to violate Miss Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Miss Reed's Fourth Amendment rights. In these ways and others, Buchanan's conduct constituted condonation of acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitute condonation of or acquiescence to Buchanan's and Proctor's behavior or gross negligence amounting to deliberate indifference. As a proximate result of their breaches, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for those harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 3. Conspiracy to deprive Ms. Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins. Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabe's, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house. They did not see Mr. O'Keefe in the house that night, and that Miss Reed had made inculpatory statements on the morning of January 29th. When they made those statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Miss Reed. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obviously and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed to continue to handle the investigation, even though they had personal relationships with suspects in the murder, which led to unlawful and unfavorable treatment of potential suspects, to continue to handle the investigation, even though they had biases against the investigation, against investigating the House defendants because of the House defendants' ties to law enforcement, to continue to handle the investigation, even though they had exhibited an extreme and personal negative bias towards Karen Reed, to violate rules, policies, and procedures in all aspects of the investigation, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury, to not secure evidence in the crime scene, to not investigate and obtain available evidence or timely and appropriately interview suspects, and to not investigate the Alberts, McCabe's, or Higgins. The McCabe's and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed or discarded. Finally, Proctor and Buchanan and Tully coordinated with the Alberts and McCabe's through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabe's and Brian Albert in a cursory manner, and all at the same location, midday on January 29th, and Nicole Albert on February 3rd. Proctor and Buchanan only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabe's. Proctor and Buchanan did not search the Alberts' phones or home where there was likely evidence of Mr. O'Keefe's murder where there was likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover up. As a result, the conspiracy between and among them, Proctor, Buchanan, and Tully, never investigated the House defendants, and instead, Miss Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct the investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of the police and criminal investigations as a result of their own work in and connection to law enforcement. As part of their conspiracy to direct law enforcement towards Miss Reed, at least some of the House defendants provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it, and along with other House defendants, took steps in furtherance of their scheme as through each of Reed's criminal trials in 2024 and 2025. The proximate result of Miss Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars of legal expenses, and serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages.
Okay, so we're getting into a lot of these allegations, which we've already heard a lot in the factual scenarios, but these are marrying them to what the law actually is. And these are allegations in a complaint. While they're taken as true, they still have to be proven. So much information is still going to be gathered in discovery. What's interesting to me is what I cared most about in this complaint was the town of Canton. And they were added, they were discussed, they weren't listed as a party, and they're not listed on any of these counts. We've also heard that MSP is going to be joined here as well. So there are going to be more amended complaints or complaints filed in other jurisdictions or attempts to consolidate all of this together. There's still more procedurally that's going to be happening in this case. But I want to make sure we go through the entire amended complaint. So we'll keep reading through the last couple counts here to see how are they going to marry. They're alleging a lot of these facts. So how do these facts prove, or how can these facts prove, if they are true, that these causes of action, that Ms. Reed can be successful in these causes of action?
Count 4, Massachusetts Civil Rights Act, MCRA, against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. Proctor, Buchanan, Tully, and the House defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws through threats, intimidation, or coercion. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' homes or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as the dog bite injuries and lack of injuries consistent with a vehicle strike. Proctor and Buchanan caused Miss Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution in Article 14 of the Massachusetts Declaration of Rights. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location of the Alberts' property, where they would claim Miss Reed dropped off Mr. O'Keefe, the Alberts, the McCabe's, and Higgins, caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Miss Reed's rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. As part of their attempts to direct law enforcement towards Reed, at least one of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it, and along with the other House defendants, took steps in furtherance of their scheme as through each of Reed's criminal trials in 2024 and 2025. Ms. Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. Moreover, House defendants and Proctor's, Buchanan's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Miss Reed to give up her defense and plead guilty to a crime she did not commit. As a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to cost, interest, and attorney's fees.
Another thing that's not unusual is multiple causes of action feeling like they're using the same set of facts and circumstances and the same witnesses, same evidence, same testimony to kind of prove it different ways. Similar damages because everything resulted from their actions. And that's kind of what this feels like as we go through a bunch of these different causes of action. Sometimes you do that because if one gets dismissed, you still have the other. Sometimes you're not sure how the evidence is going to come out. Sometimes you're not sure what you're going to be able to prove. So sometimes you'll see multiple counts, and some may apply to some defendants and others, other defendants, and others, both sets of defendants. So kind of you see a combination of that and how the strategy behind the legal strategy behind civil litigation and how different it is than, again, criminal cases, which is much more normal for everybody online to follow.
Count 5, common law malicious prosecution against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins. The preceding paragraphs are incorporated herein by reference. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' homes or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and the lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Miss Reed's indictment, arrest, and prosecution. Miss Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Buchanan, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. These criminal proceedings were instituted with malice and as evidence by Proctor's, Buchanan's, and Tully's knowledge that it was based on false evidence, Proctor's, Buchanan's, and Tully's bias and ill will towards Miss Reed, and for the improper purpose to protect Proctor's and Proctor's friends and acquaintances, the Alberts. The criminal proceedings terminated in Miss Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. By falsely representing that Mr. O'Keefe never entered the Albert home, and by relocating the body to the location on the Albert property where Jennifer McCabe would claim Miss Reed dropped off Mr. O'Keefe, Brian, and Nicole Albert, the McCabes, and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. As part of their attempts to direct law enforcement towards Reed, at least some of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it, and along with the other House defendants, took steps in furtherance of their scheme through each of Reed's criminal trials in 2024 and 2025. As a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury.
Yeah,
Count
the
six.
damages part is really interesting to me because that can just be unbelievable if they can get past the liability. I mean, the damage part's going to be huge.
Count 6. Intentional infliction of emotional distress against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' homes or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with the vehicle strike, Proctor, Buchanan, and Tully caused Miss Reed's indictment, arrest, and prosecution. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Miss Reed dropped off Mr. O'Keefe, the Alberts, the McCabes, and Higgins, caused Miss Reed's wrongful indictment, arrest, and prosecution of Miss Reed. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. As part of their attempts to direct law enforcement towards Reed, at least some of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of the separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it. Along with the other House defendants, took steps in furtherance of their scheme through each of Reed's criminal trials in 2024 and 2025. The defendants knew or should have known their conduct would cause Ms. Reed's emotional distress, since it would lead to her prosecution for murder and other crimes, and the conduct did cause and is causing Ms. Reed severe emotional and physical distress. The defendant's conduct perverted the justice system, allowed Mr. O'Keefe's true killer to escape liability, and threatened to imprison Miss Reed. It is the type of behavior that threatens civilized society and is therefore extreme and outrageous. As a proximate result of the defendant's actions, Miss Reed suffered serious emotional and physical distress and injury. Count 7. Civil conspiracy against Proctor, Buchanan, Tully, the Alberts, McCabe's, and Higgins. Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concerted efforts, and among their many other misrepresentations, the Alberts, McCabe's, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made the inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Miss Reed. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for and implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of anyone else. In furtherance of the conspiracy, Proctor, Tully, and Buchanan agreed to fabricate, plant, and manipulate evidence purporting to show that Miss Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, Proctor, Buchanan, and Tully carried out multiple overt acts, including damaging the taillight on Miss Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th prior to the MSP CERT team's arrival on site. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Miss Reed's Lexus SUV sometime prior to the vehicle's processing by MSPCL on February 1st, 2022. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and Higgins. The McCabe's, the Alberts, and the Higgins coordinated through text messages, phone calls, and information on belief and conversations on information and belief conversations. Higgins and Brian Albert coordinated through telephone calls and on information and belief text messages on their phones, which were later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCabe's through his sister, Courtney, who spoke frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabe's and Brian Albert in a cursory manner the morning of January 29th and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the Alberts' house. Proctor, Buchanan, and Tully also interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins' phone or search for communications between him, the Alberts, and McCabe's. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully also did not search the Alberts' phones or home when there was likely evidence of O'Keefe's murder. Further, Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Following Mr. O'Keefe's death, among the other acts in McCabe's and Albert's agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Miss Reed's car. As part of this common plan, Brian Albert and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 29th for how long it takes a person to die in the cold. One or more of them relocated Mr. O'Keefe's body and deposited it in front of the Alberts' house, where Jennifer McCabe claimed Miss Reed had dropped Mr. O'Keefe's off earlier. The McCabe's and Alberts then coordinated what they would say to the police, all of them falsely telling investigators that Mr. O'Keefe never entered the house. At least some of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it, along with the other House defendants, took steps furtherance of their scheme at through each of Reed's criminal trials in 2024 and 2025. Proctor Buchanan Tully and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor Buchanan and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of the police and criminal investigations as a result of their own work in connection to law enforcement. Proctor's, Buchanan's, Tully's, and the House defendants' conduct described herein were unlawful and torturous. Among other things, they constitute intentional infliction of emotional distress, negligence, common law malicious prosecution, and violations of Miss Reed's rights pursuant to the United States Constitution and the Massachusetts Declaration of Rights. As a proximate result of the defendant's actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury.
And then she respectfully requests a jury trial on all matters so triable. Will we get that one day? We will see. What I want to know from everybody listening is, now that you've heard all the facts in this amended complaint and you've heard them married up with the law on the causes of action, which one do you think is the strongest? Which one do you think is the weakest? These are not your average causes of action. Federal court is different than state court. So just be ready for a different vibe and a different feel as we, kind of go along with this case. I will still provide, obviously, periodic updates. It's not going to be something that happens daily or weekly in this case. But we're here. We've read the entire amended complaint. You know exactly what it says. Let me know your thoughts on it and what you think is going to happen in this case. We are now going to clip to the Proctor cell phone motions breakdown that was in the second half of the other video. If you want to stick around for this marathon, you can hit the like button. This has to be one of the longest videos I think we've ever done. But we will clip that on here. I appreciate you guys. I appreciate everybody in the comments that is understanding and supportive and giving grace. I appreciate that more than you guys can know and more than I can say on this. We'll continue to grind on, continue to try to do our best here every single day. John, thanks for coming in and helping me read through the rest of that complaint. That's all we got. What'd you say?
Anytime.
No, I appreciate it. People like you a lot more than the AI reading of the complaints. They were like, the robot is skipping words. The robot sounds weird. So we're not doing that anymore. But that's all we got. Let's cut to Proctor. So this Proctor cell phone stuff right after we had a stipulation. We had multiple hearings and fights about it, stipulated that they could use it for that state civil case. Well, that might not be good enough for Karen Reed and her team. On February 26th, the court allowed the Commonwealth's motion seeking permission to provide to Karen Reed's counsel certain documents and data recovered from former MSP trooper Michael Proctor's personal cell phone. These documents and communications were subject to existing court orders and now are subject to the court's most recent order dated February 26th. In that order, the court limited Reed's use of the cell phone data to the pending case captioned O'Keefe v. CNC Hospitality et al., and imposed certain restrictions on how the data could be stored, shared, and utilized pursuant to an agreement with the Commonwealth. So Reed's team and the Commonwealth agreed on this. That's the agreed to stipulation or stipulated order. But now that her counsel has reviewed the data from Proctor's phone, and that's a big wind-up sentence. Now that Ms. Reed's team has actually been able to look at Proctor's cell phone, it's so much worse, and it gives us evidence for more lawsuits. And there's two ways to look at this. If you're Proctor, if you're the Commonwealth, you really shouldn't care, in my opinion, as long as they're using it for legally appropriate reasons. But if you're Proctor, you're like, Judge, what was the point of the stipulation? Why did everybody fight about all this? Why did you, ask them to agree to it if they're going to ask for an inch? And once you give them the inch, they're going to try to take another inch. They're going to try to take a mile, judge. And pretty soon the order is not going to matter. They're just going to keep asking for things. And I get that. But this happens so often in discovery. Like, judge, we just need this to look at it. There might be nothing there. But when there is something there, it's like, judge, now that we know, we have to do what's right. And you know what? The pesky interests of justice always tend to rule in the courtrooms across America. And when you say, judge, it's so clear that other causes of action are appropriate now that we've looked at this information. Be tough for a judge to say no to that. But when will the judge allow it? If they allow it is a big question. Reed requests that the court make one amendment right now. They might ask for another amendment later. We're not going to say this is the only amendment, but right now we're just asking for one amendment to its February 26 order and permit her to also use such communications in connection with a separate civil action Reed will bring against the Massachusetts State Police and town of Canton. So there she's telling them, we're suing MSP and the town of Canton. We've seen an amended complaint with town of Canton, not MSP yet. In Bristol Superior Court, when the MGL presentment periods elapse, these communications are highly relevant to the negligent hiring, training, and supervision claims that Reed intends to assert, among others, against MSP and Canton, arising out of the same facts and circumstances as the O'Keefe litigation. So maybe they're going to try to another time to bring all these together, right? In state court. Maybe that fight's not completely dead. Reed should be permitted to use this data in connection with her pleadings that will commence her new case in the same exact manner this court has permitted her to use it in her defense of the wrongful death case filed against her. So this seems kind of simple. It's like, judge, you said it was appropriate to use this stuff in a civil case. I happen to be the defendant. So why wouldn't it be appropriate for me to use it in a civil case where I am the plaintiff? And by the way, if the judge says no to this, I think this is more of an argument to consolidate these cases if Reed's team really wants to try to do that again, or actually try to do that. They've talked about it. But if you're saying I can use it in this case and not this case, judge, it's completely unfair for me to be able to fight this case, same facts and circumstances, when another judge is only letting me use it for that case, this case. We need to bring all these together because the discovery is not the same. Diller said the discovery might be the same and we might consolidate them for discovery purposes. That would allow me to use this for discovery purposes. This feels logical. It's not, yes, it's an amendment, but it's not an additional inch, right? They asked for an inch, and I was talking about arguments that the other side could make. Are they really asking for another inch? Or is it the same inch with a different name on it? Very similar set of facts and circumstances. Allowing Reed to use the documents in two superior court cases instead of one, but subject to all the same other restrictions Reed and the Commonwealth agreed to, will also not present any additional risk of improper disclosure of protected information. Let me read these footnotes. Reed initially tried to bring these claims among other third-party claims in the O'Keefe litigation. The plaintiffs and multiple proposed third-party defendants opposed the attempt, and Reed eventually filed a separate proceeding, which was subsequently removed to federal court. Reed cannot bring her claims against MSP in federal court because of the Commonwealth's 11th Amendment immunity requiring new state court action. Okay, so MSP is going to get its completely separate lawsuit. That's what this sounds like. MSP is not going to be with that federal lawsuit. So they're going to get a completely separate state lawsuit. Reed does not believe that any of the data on, and again, it's like now we're going to have 3 lawsuits going. We should consolidate these, in my opinion, for judicial economy, but what do I know? Reed does not believe that any of the data on Proctor's phone should be subject to any confidentiality provisions or orders other than references and information relating to SA or harassment victims or individuals whose images were shared without their knowledge. But in order to avoid, every time they say that, it sounds really nefarious, but could be nothing. But in order to avoid additional motion practice at this time, Reed agrees to accept such restrictions. So they're saying, Judge, we don't even think we need the stipulation in the order that you did restricting this stuff, but we didn't want to keep fighting about it, and we were able to use it for what we needed to, but now we really need it for this. Therefore, there is no legal or practical basis to deny Reed the right to use this data in support of her affirmative legal claims. So it's like, what's the difference, Judge? If we're able to use it to defend ourselves in civil claims, why can't we use it to prosecute when it's these same exact people, same exact facts, everything's the same? So Reed respectfully requests that the court amend its February 26 order and permit Reed to also use the documents and information subject to that order in connection with the litigation she is preparing to file against MSP and Canton in Bristol Superior Court, including in pleadings and filings, and by sharing it with counsel to MSP and Canton once they agree in writing to abide by the court's order. So there are two other parties or non-parties that have something to say about this. Michelle asked, will we ever get the witness depositions? Get to witness the depositions? My guess is no. It's not for the federal court ones, but we may hear some impeachment questions. Like in your deposition, you said this. In your deposition, you said that. But we'll see. All right, let's now get to the Commonwealth's response to that motion for permission. The Commonwealth responds to Karen Read's motion for permission to use materials that this court has limited dissemination of in litigation not before this court. Karen Read is not a party to these to these pending criminal cases, nor has she moved to intervene. Rather, Ms. Read, in a highly unusual set of procedural circumstances, seeks this honorable court to act as the gatekeeper for discovery in unrelated and anticipatory civil litigation. It's also bad because Proctor destroyed his phone, or maybe we wouldn't even be having these conversations. On January 23rd, the Commonwealth moved to provide, pursuant to a civil subpoena, information derived from former MSP Trooper Proctor's personal cell phone. Commonwealth motion was a good faith attempt to resolve a subpoena and pending motion to compel in the civil matter. A wrongful death action against Karen Read pending in Plymouth County Court. Prior to the filing, the Commonwealth engaged in extensive discussion with Ms. Read's counsel and proposed the order incorporated in those discussions. Agreed to at the time was the use of material would be limited to the O'Keefe litigation, whereas a confidentiality agreement signed by all parties and endorsed by the Plymouth Superior Court restricted discovery in a manner substantially equivalent to the defendants in the above captioned and other unrelated criminal cases who similarly received this material through a court order. Following a hearing on February 26th, and over the objection of Michael Proctor, this court permitted the Commonwealth to produce to counsel for all parties in the pending O'Keefe litigation portions of Proctor's cell phone extraction related to bias and to search for any material related to the death of John O'Keefe. And that's the point, is those limitations, the show of bias and the limitations of the death of John O'Keefe, it's the same exact set of circumstances we're talking about in the new litigation that Karen Read wants to use these texts for. It's not like she's saying, oh, I want to go use them for some totally unrelated matter. That's the problem for the Commonwealth and for Proctor. The cell phone extraction related to bias was produced to the parties on March 9th, 2026. So that's how quick Karen Read's team is moving, because these motions were filed in late March. So within a couple weeks, they were able to review all the data and say, we got more good stuff we need right when that presentment period at 6 months ended. We got more we want to roll with. Ms. Read now unilaterally, because there was an agreed upon stipulated order before, that's why they're saying unilaterally, they didn't even ask us, Judge, if we'll come in with them and everybody agrees to use it that way. But unilaterally, they moved to amend this court's order to go outside of the protective order. Oh, gosh. For discovery purposes and to permit the use of the material for new claims against the MSP and the town of Canton. Let's read the footnote here because there was one I want to talk about. On December 10th, this court allowed the Commonwealth's motion to provide biased material from Proctor's cell phone to counsel for the town of Canton and the Peace Officer Standards and Trainings Commission. However, the use and dissemination of the material to those parties is equally restricted, and we can equally restrict it here. That's the point, because those people could potentially be seen as outside the O'Keefe litigation. The Massachusetts State Police currently have no access to this material without further amendment to this court's order. I can think of a way to fix that. Why don't we also give it to MSP? So everybody can have access to this that's involved in the litigation, the new litigation that Read's going to file, and we can still restrict it. But it seems like the interest of justice is pretty clear. She should have the ability to file these lawsuits. Ms. Read indicated she previously sought to raise these claims, but due to jurisdictional and seemingly strategic decisions, has yet to file the action in state court. Under Massachusetts Rule of Civil Procedure 8A, Ms. Read is not prohibited from bringing her claims without this material, as only a short and plain statement of the claim is necessary. Okay, so here's where they start to get into maybe we can win on a technicality. Because in my opinion, this is a pretty easy answer that they should allow these text messages to be used in a sister case. There's no other way to describe it. And Karen Read's team tried to do this all at once. So to make the arguments that these are different cases is kind of like, they tried to make it one. But technically, they might be right. She can file this lawsuit without them because you don't need to cite or attach text messages. You can put upon information and belief and put a short and plain statement of the case. But sometimes motions to dismiss are like, we need a more definite statement. We need more information. We have to know how to defend ourselves. That happens to us sometimes in cases where like, okay, fine. We'll lay it all out there publicly against your client because you asked for it. But if the court rules in the Commonwealth's favor here and says, yeah, you don't need it for the complaint, eventually they're going to need it to A, prove their case at trial, and B, depose a bunch of witnesses, maybe every witness. They're going to need to use them in their discovery questions because they want to get specific. They want to get the information. They want to prove this case. So even if you agree with them here, it's just kind of delaying the inevitable is what it feels like. Rather, Ms. Reed's request before this court is merely to seek one-sided discovery of unasserted claims. I'd be willing to guess or bet that they would be totally fine turning Proctor's private text message download or phone download over to the MSP too. What do they care? It's discovery. It's not hide the ball. It's not trial by ambush. Go ahead. Have at it. MSP can have it too. Give it to everybody as far as we're concerned. That's how I would be if I was representing Karen Reed. I'm not going to block myself to be able to use it just because MSP doesn't have it yet. Sure, we gave it to the town of Canton, give it to MSP, give it to everybody because we want to use it in this civil litigation. That's the important part. If you feel like it's important to be used as evidence, you're not going to care if the defense has access to it too. Frankly, they're going to be able to ask you, what evidence do you have to prove these claims? And his cell phone download, I'd hazard a guess, is going to be a big part of that. A party issuing a subpoena for documents and electronically stored information must serve a copy on all other parties before serving the non-party. It is the Commonwealth's position that Ms. Reed's request is untimely and unduly burdensome to this court. I mean, that just whatever. There is no pending civil action and no subpoena issued, no court governing discovery, including no confidentiality agreement among the parties, and no legal basis for justification for this request. So that might be another good point, but only delaying the inevitable. So yeah, go ahead, file the lawsuit. Once you get a judge assigned to the case who can enter a protective order restricting the use of this cell phone download, you can't have it or use it. They already have it, but you can't have it as Reed's plaintiff's counsel in this case, even though you have it as Reed's defense counsel in this case. So technically, this may be a reason where the judge says, okay, I'm going to hold off on making a decision until they have a judge in place that can also restrict the use of this discovery. As was done previously, the Commonwealth is amenable to discussions as a third-party record holder if and when a subpoena is issued in a future civil action such that discovery can be similarly governed. I wonder if they've ever litigated an issue as we're just a third-party bystander record holder. I wonder if they've ever litigated an issue quite this much. I don't know the answer. It's just a real question. Moreover, when the Commonwealth moved to produce this material, it was done in response to subpoena, but also in fundamental fairness to all parties in the civil action. It's like, yeah, but they already have it now. They don't have to subpoena you because they already have it. But I guess they want them to subpoena them as Karen Reed's plaintiff's counsel instead of Karen Reed's defense counsel in the other case, which maybe they'll have to because legally, procedurally, okay, if they want to do it that way, fine. But when they do and they have a new judge, it should be a similar order. It should still be protected. It should still be restricted, no doubt about that. But it's the same use. As all were signatories on the confidentiality agreement, Ms. Reed's request would place parties in the currently unfiled action at a disadvantage as they lack access or means to use the material in similar fashion, notably resulting in an onerous and unduly burdensome task for this court to continuously schedule hearings, amend its orders, and serve as the gatekeeper for anticipatory and unrelated civil discovery disputes. Therefore, this honorable court should deny Ms. Reed's motion or alternatively take no action and reserve for a time where there is appropriate legal process. And that might be what happens for the reasons I've already kind of explained. Okay. Speaking of Proctor, what does he have to say about this? Well, third party Michael Proctor is also opposing Karen Reed's motion for permission. Now comes Proctor and hereby requests that the court deny Karen Reed's motion for permission to use a cell phone. As grounds, Proctor states, Reed has not met her burden to establish that the data from Proctor's personal cell phone is relevant or material to any claim she might have against his former employer or the Canton Police Department on any negligent hiring, training, or retention claim under MGL 258. So, negligent hiring, training, or retention. Can you think of some things that might be important there? Thumbs upping some text messages, saying an A+ investigation when later you're fired for your investigation and your bias that you were shown throughout it, retaining officers that maybe you shouldn't retain, training people not to share highly sensitive investigative material with sisters and friends and using people as conduits potentially, saying you're searching for certain things on phones or, of course, searching for those things on phones, saving certain pictures of maybe victims or nudes on your phone. We don't know what's on Proctor's phone. You can see how this stuff could become relevant for these types of claims. Furthermore, upon information and belief, there are no protective orders in place in any of the Superior Court cases referenced by Ms. Reed so as to prevent further dissemination of the February 26 production. Moreover, the release of said data would certainly compromise Proctor's privacy interests and possibly those of other individuals referenced in the data. So here's the problem. His best argument is, let's delay this, judge, because he's going to rehash some of the other arguments he made to stop it and block it from going to the other case, which were losers and are still going to be losers. Should the court allow Ms. Reed's motion, Proctor respectfully requests the court also issue an order to the Norfolk DA's office mandating that it turn over Proctor's undersigned counsel copies of the documents that it produced to Ms. Reed's counsel following its February 26 order of production. I feel like they could do that right now, as the NDAO has not produced copies of same to counsel. Yeah, I feel like they could make a good argument for that right now. And I think they should have to produce those to Proctor. They're going to be used against him. But again, he's not a defendant in the other case. So he has more of a claim to them as a defendant in the case where Reed wants to use this download. The February 26 production was extracted from Proctor's personal cell phone in or about September 2025. Upon information and belief, it contains millions and millions of pieces of data, allegedly going back almost 13 years. According to the NDAO, the data contains highly sensitive information, including images of intimate body parts of people, screenshots of Facebook posts by non-participants, full phone numbers and or personal email address of others, and the name of an SA victim. Again, we have a way to protect from all of this. It's already been drafted and stipulated to. The only addition is the same restrictions apply to yet another case. Upon information and belief, the February 26 production contains some of this highly sensitive information, and Ms. Reed acknowledges same in the footnote 2, page 2 of her motion. The data references information relating to SA or harassment victims or individuals whose images were shared without their knowledge. Again, this lawyer is just doing his job arguing for Proctor, but it's like, that looks and sounds really bad. It sounds like you're admitting some major stuff is on your cell phone that should not be there. However, Ms. Reed's motion fails to explain how any of this personal information would be relevant to a negligent training, hiring, and supervision claim against MSP. So maybe the judge will have a hearing and be like, explain to me why you need it for this case. To me, it seems pretty obvious, but again, maybe the judge will, that would be totally appropriate if the judge required that. There is no allegation anywhere in her motion that MSP knew or should have known about this information on Proctor's cell. Well, it depends on what you mean by MSP. Individual supervisors, multiple supervisors, what's in your policies and procedures manual. Nor does it allege that such information might have been discovered during a background check of Mr. Proctor. Prior to hiring him, available to Proctor prior to hiring him, because that would be the negligent hiring. What did they know about him? Should they have known? They hired him anyways. Those are the types of things. A lot of times this happens in, like, we've had this happen in trucking cases where they hire a driver who's either has no driver's license, a suspended driver's license, gotten in a million accidents, speeding tickets, whatever it may be, and you still hire him to drive a killing machine in a big truck. Moreover, Ms. Reed's motion fails to explain how the data might be relevant to a claim against the Canton Police Department, an entity for whom Proctor never worked. Town of Canton, I think, is what he means there. Additionally, the use of this data is certain Superior Court proceedings and almost certain to be leaked publicly and is likely to be used in public hearings and or trials. And that's a legitimate fear, is the public gets their hands on this and it explodes. Because it sounds like there's some bad stuff in there. I mean, these motions just make me think there's more and more bad stuff in Proctor's phone download. I don't know what's there. Upon information and belief, there are no protective orders, confidentiality orders in place in these other civil Superior Court matters. He's right. And again, this might be a reason why we delay the inevitable. Furthermore, the internet is already rife with information, data concerning Ms. Reed's trials, her conviction for operating under the influence, and other information regarding Proctor, the witnesses in the case, and the decedent John O'Keefe, non-parties and non-witnesses to the case, and the matter generally. If Reed's team is allowed to say it their way and the way they view everything, so is Proctor. He's like, hey, we had that trial where Reed got convicted, and we're just officers and witnesses in the case. In short, the use of this information will likely add fuel to the fire. That just can't be a consideration of the court, that something might get leaked. So we're not going to allow somebody to use it as very legitimate evidence in their civil action. They have a right to file this lawsuit, especially against law enforcement if they have overstepped their power and abused their authority or screwed up by hiring, horribly training, or retaining bad officers and therefore damaging somebody. Like, we as citizens have right to file these lawsuits. In short, the use of this information will likely add fuel to the fire. I already said that. It is well known that Proctor, his family, as well as independent witnesses in the underlying criminal trial have been followed, tailed, photographed, and had their personal privacy interests interfered with by Ms. Reed's followers. To allow this information to be used in other superior court cases will prejudice Proctor. It will definitely prejudice Proctor. Witnesses in the underlying criminal matter might prejudice them too, and possibly other unnamed individuals, and cause further embarrassment to and harm to their reputations. Wherefore, Proctor respectfully requests that this court deny Ms. Reed's motion, issue an order to the NDAO mandating it produce to undersigned counsel copies of the documents produced to Ms. Reed. Frankly, you probably don't deserve those documents or don't have standing to get those documents if we're just talking about the other case for which you're not a party. But you are a witness. They're going to be used against you in your depot. Plus, you already have them. But to know exactly which ones got turned over, I could see why that should be turned over. Undersigned counsel would certainly be willing to execute any and all documents indicating an intent to be bound by any protective orders. Yeah, as I'm sure Ms. Reed's team would as well. So, what do we think is going to happen here? I think Reed's team eventually, maybe not yet, but eventually will be able to use Proctor's cell phone download in the additional cases against MSP and Town of Canton. I think it's virtually the same set of circumstances, different causes of actions, same set of fact pattern, John O'Keefe's death, what happened, the investigation surrounding John O'Keefe's death, Karen Reed's, what do they call it? The false narrative that she produced. I assume that's going to be part of their defenses in that case, part of the arguments they argue in the case where Karen Reed is the plaintiff. So I think all of this is fair game. I absolutely think they should turn it over to MSP. I think Proctor, especially because he's a defendant, if they use it in that case, should be turned over to him as well. Everybody should have access to the discovery with the restrictions the court has already put on it. But we need a judge sometimes to do that, right? In the case. So once they get a judge in that case, they're able to file a lawsuit without it, get that protective order, and then use it throughout the case. So I do foresee it potentially delaying the inevitable. So maybe they don't get to use it just yet, but eventually I really think they will. I think it wouldn't make logical sense that they're able to use it in one and not the other. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe.
You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com.
And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.